Hello, and in this video I'm going to be talking about the common law and exemption clauses. Now, by exemption clauses I'm also referring to limited liability clauses, which limit a contractual party's ability to claim liability of the other contractual party, if that makes sense, and exemption clauses where you completely exempt your liability should any breach or negligence or whatever occur. So the first question to ask when we're looking at the common law and how they deal with these exemption clauses is, has the term been incorporated? Because if it has not, then there's no point searching for a remedy. It just will not apply and then there will be a breach. So previously, like when we had a rule of absolute contracts focused system, exemption clauses, they were applied regardless, basically, because pacta sunt servanda, you had all agreements must be kept, and freedom of contract was said to be king. So this is clearly demonstrated in the 1930s case Thompson and LMS Railway. Now what happened is that the claimant was injured, I think while stepping off a train or something, and basically they went to claim that liability, some negligence, some money for their personal injury. But however, because the ticket stated they were subject to terms and conditions on the platform, so then they said, actually, we're excluded from paying the liabilities, what the railway company said. However, the claimant was illiterate and could not read the signs, so she argued the exclusion clause was not incorporated in the contract, as the railway company had not brought the clause to her attention. So I think this is a great case for showing that, exclusion clauses, they haven't always been so consumer welfarism, the courts when dealing with them. But also this point shows that up till today, just because you are illiterate or you don't read the contract, ignorance to the law is not an excuse for the law, so you can't use that as an excuse. So there's also that case, less strange case, where she signs a contract without looking, then afterwards has issues, but they say that actually, you should have read it. So it's that kind of same harshness to the law. But let's have a look at actual cases now. There's only a handful which demonstrate how the courts deal with whether a clause is incorporated. Now, the main way they deal with it is by having a look at whether there is notice and what are the industry standards, and whether the liability that has occurred, is it a reasonable liability, is it unreasonable? These are the kind of things that the courts take into account. So the first, the infamous case of 1949, Ollie and Marlborough Court. Now the claimant booked into the hotel. The hotel, at the back of the door inside the hotel room, sought to exclude liability. Now the claimant had her fur coat stolen because the reception just left the keys lying out. So the reception over there was negligent. Now the notice was ineffective, as the notice only came after the contract had been entered into, and so therefore the exclusion clause could not apply, and they were able to claim liability off the hotel. Similarly, in Thornton and Shoe Lane Parking, 1971, the claimant was injured in a car park because of an accident, which was partly to do with the defendant's negligence. Now, the claimant was given a ticket in entering the car park after putting money after entering the car park, and on the ticket is stated that it was subject to terms and conditions which were displayed on the inside of the car park. Now, one of the terms was that excluded liability for personal injuries arising through negligence. So now the courts had to again decide, was this incorporated? However, again, they said that no, it was not incorporated. The machine itself was an offer, and the acceptance was by putting money in. The ticket was therefore dispensed after the acceptance had took place, and therefore there wasn't enough notice, and the client wasn't aware of the term and getting into it, and it wasn't reasonable to exclude complete liability or personal injury, especially now we have statutory regulations with the Consumer Unfair Contract Terms Act, which basically says, I think it's in section 2, that any sort of injury arising from negligence, you can only limit it to a certain extent. If it's death, you definitely cannot exclude it. Another case, the last case that is good for showing incorporation, is Chapelton and Barry Urban District Council 1940. Now, a man rented 2 deck chairs. As a result, he was given a ticket. Now, this was another standard form contract, as we've seen in the previous 2 cases. He fell through the deck chair. He wanted to claim liability. However, they said that there was an exemption clause and it was written on the ticket. Now, the first thing was, he wasn't drawn enough attention to it, and second thing was the ticket actually the terms, or was it a mere receipt? And the courts held that actually it was a mere receipt, and a mere receipt, because basically the 2 parties, they didn't intend for that ticket to be contractually binding. It was just a receipt to say you've bought 2 chairs from us. So how can anything that's on there be part of the contract? Especially because you can't get the ticket unless you've actually went and got the chairs. So they said that this clause, just like the other 2, were not incorporated. Now this video is getting long, so before I end it, I just want to talk about how courts interpret it if it was incorporated. Now, there's something called the contra prefrontal rule. Now, this is basically that you interpret the clause against the person who wrote it, so basically the consumer, and this is how common law would deal with it. For example, in Wallace, Sons, Wells and Pratt Haynes 1911, a seed sale clause said the sellers gave no warranty, express or implied, as to the seed's description. Well, so when the seeds arrived, they were completely different to that than they had entered into a contract to. Now, they said that clause doesn't apply to conditions of the contract, which is the type of receipt is a condition of the contract. It only applies to warranties. So this is a way in which the courts, they interpreted the exclusion clause against the company who wrote it. Similarly, in John Lee and Son, and Railway Executive 1949. So goods were stored away in a railway warehouse to a railway warehouse which was let to a tenant. Now these were damaged in a fire, and so the tenant tried to get liability because they said that it was to do with the negligence of the landlord, because it was actually to do with an engine that had caused the fire. The defendant said, actually, no, we are exempted from this because they had an exclusion clause which said, but for the tenancy hereby created would not have arisen. So if you had not agreed to our terms, you wouldn't be in the tenancy. So therefore it is incorporated. However, the court interpreted this against the landlord and said the company was liable because this fire is nothing to do with the tenancy. This fire could have happened regardless. It's to do with the negligence of the train, the engine which sparked it, not to do with their relationship as tenant and landlord, and therefore the exclusion clause did not apply. Hope this video helps, and thank you for watching.